Damages in contract law are a remedy available for breach of contract under common law. Damages are an award of money to compensate the innocent party. The primary purpose of damages in contract law is to place the injured party in the position they would have been in had the contract been performed. This was established in Addis v. Gramophone 1909. The claimant brought an action for breach of contract relating to wrongful dismissal. He claimed that the level of damages should reflect the fact that the circumstances in which he was dismissed damaged his reputation and ability to find suitable employment. However, the court held he was limited to claiming wages and loss of commission during the contractually agreed notice period. There was no right to exemplary damages or damage to reputation in contract claims. Such claims would have to be actioned in the law of tort. An award of damages in contract law is subject to the application of the rules on causation, remoteness and a duty to mitigate loss. An intervening act may break the chain of causation unless it is foreseeable according to the Monix Steamship v. Karlsheims Oljefabriker 1949, where it was held that the defendant should have foreseen the outbreak of the war. Under the rules of remoteness of damage in contract law set out in Hadley v. Baxendale 1854, a claimant may only recover losses which may reasonably be considered as arising naturally from the breach or those which may reasonably be supposed to be in the contemplation of the parties at the time the contract was made. The application of this principle can be seen in Victoria Laundry v. Newman Industries Limited 1949. The claimant purchased a large boiler for use in the dyeing and laundry business. The defendant was aware that they wished to put it to immediate use and knew the nature of their business. The delivery of the boiler was delayed in breach of contract and the claimants brought an action for the loss of profit which the boiler would have made during the period in which the delivery was delayed. The claim contained a sum for a particularly lucrative contract which they lost due to the absence of the boiler. It was held that the claimants could only recover losses which were in the reasonable contemplation of the parties, which included the loss of profit that could be expected from the lack of use of the boiler. The claimant could not recover for the loss of the exceptionally lucrative contract since the defendant was unaware of this contract. In Charnocow Limited vs. Kufos, the Heron 2, 1969, a contract for the carriage of a cargo of sugar was delayed by 9 days. The market price of sugar dropped following this delay due to the arrival of another cargo of sugar. The claimant sought to recover the difference from the defendant for their breach of contract. The defendant argued the damages were too remote since it was just as likely that the market price could increase. The court held that under the second limb in Hadley v. Baxendale, it was only necessary that the losses were in the reasonable contemplation of the parties as a possible result of the breach. There was no requirement as to the degree of probability of that loss arising. Since the defendant must have known that market prices fluctuate, the loss would have been in his contemplation as a possible result of the breach. In Parsons v. Utley Ingham 1978, the claimant pig farmers purchased a food storage hopper from the defendant for the storage of pig feed. The hopper was installed negligently and a lack of ventilation caused the pig feed to go moldy. As a result, many of the pigs contracted E. coli and died. The claimant claimed over £36,000 in respect of the loss of profit, vet bills and other costs relating to the death of the pigs. The defendant contended this damage was too remote as it was not in the contemplation of the parties that the poor ventilation would cause death of the pigs. The court held that the death of the pigs was a natural result of feeding the pigs mouldy food within the first limb of Hadley v. Baxendale. There was therefore no need to consider whether the death by E. coli was in the reasonable contemplation of the parties under the second limb. The claimant is not permitted to allow their losses to mount up. They are under a duty to take reasonable steps to reduce their loss. This was established in Paisu v. Saunders 1919, where the claimant should have accepted the defendant's offer to deliver the goods for cash at the same price, rather than buying them elsewhere for a higher price. In summary, damages in contract law aim to put the parties into the position they would have been in, had the contract been performed. Damages are subject to the rules on causation, remoteness of damage and the duty to mitigate. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website which provides lecture outlines and case summaries. See also www.elawrevision.org.uk for revision games and quizzes. Thanks for watching.